Advocates in Alberta say they are ready to fight against provincial efforts to limit transgender youth access to sports, healthcare, as well as new rules around gender expression in schools. Danielle Smith's government tabled legislation that seeks to invoke the notwithstanding clause to shield 3 different bills from legal challenges.
As a government, we have a responsibility to provide clarity, a responsibility to protect all children and youth, and a responsibility to give parents, not institutions or courts, the primary role in life-changing decisions about their children. This government does not turn to the notwithstanding clause unless the stakes warrant it. And in this case, the stakes could not be higher.
Critics have panned the legislation, and multiple groups say that they plan to challenge the legislation in court. That includes Egale Canada, which advocates for 2S LGBTQ+ people. And joining me this morning is Egale Canada's Director of Legal, Bennett Jensen, joining us this morning from Ottawa. So nice to see you this morning.
Good morning. Nice to be here.
So we just heard Danielle Smith speaking there, and the Premier said that the stakes could not be higher. And she said that to justify her use of the notwithstanding clause. Let's talk about how harmful, in your opinion, this is and the lasting impacts that this could we could see within your province.
Well, I agree with the Premier that the stakes could not be higher. I just disagree with the cause of those stakes. So what happened yesterday was that a government acted for the first time in Canadian history to use the notwithstanding clause to limit access to healthcare, and in doing so reversed on a number of representations that government had been making to the Albertan population, and deployed a lot of misinformation. So, for example, in the quote that you just ran, in the audio that you just ran of the Premier, she talked about deferring to parents. What we're talking about here is medical care that is recommended by the treating physician, that in the vast majority of cases, parents are seeking for their children. So to see a conservative government at that, overreach into the medical decisions parents are making into their children's lives, and to seek to remove the ability of courts to review and make determinations on the constitutionality of those actions by the government, it's really chilling.
Let's talk a little bit more about that, because the clause, yes, it's being used to shield 3 laws that impact transgender people from legal challenges and include restrictions to some medical treatments, pronoun changes, and, as we've been mentioning, participation in sports. And you and your group are challenging 2 of those pieces of legislation. Can you dig in a little bit more on the potential harms if these remain in place?
Yeah. So, the first challenge that we had initiated was to the ban on gender-affirming care. And we sought an injunction to block the law from being in effect while our constitutional challenge proceeded, and filed a lot of expert evidence. The government had the opportunity and filed a ton of expert evidence. The judge overseeing the matter had the benefit of, I think, 45 different witnesses, and in early this summer issued on the basis of that evidence that irreparable harm would flow to gender diverse young people if the law was allowed to be in effect while our challenge proceeded. And so what we're talking about there are life-altering changes that happen through puberty that result in gender diverse young people having bodies that aren't theirs, that don't work for them. So some of the misinformation that happens in this context is that the government is acting to prevent life-altering changes or permanent changes, and that couldn't be farther from the truth. What we're really talking about for gender-affirming care for young people is normally the use of puberty blockers, which pause the onset of puberty to allow that young person more time to figure out who they are. And so without access to those puberty blockers, you are having life-altering permanent effects that happen to all of us during puberty. And for a young trans girl, that might mean growing facial hair, developing an Adam's apple, these physical changes that would be horrifying to any young girl. And so those are some of the changes we're talking about. But again, you don't have to believe me. You can listen to the judge who found that these would cause irreparable harm.
Let's talk about the court challenges and the challenges in pursuing that avenue. What do you anticipate in the coming days and weeks as you pursue this with your group?
So the main message is that the court challenges aren't done. We've said from the beginning that we believe all three bills, so including sports, are unconstitutional, and that we intend to challenge all of them. We've just been taking them in turn based on the order in which they were coming into effect. But the court challenges will continue. I think the government was saying to the press earlier this week that they expected that all the litigation would go away as soon as they introduced this bill. But unfortunately, that's not how a constitutional democracy works. The government can't just opt out of the court process, and we intend to continue fighting.
Let's talk about the notwithstanding clause. It is rarely used. We've now seen it used twice, very close together in Alberta, as we saw it used recently to end the teacher strike in that province. What implications do you think this has, not only in Alberta, but across the country?
I think we really need to remember what an extreme tool the notwithstanding clause is. No other constitutional democracy on the planet has a similar tool, and that's because the rights, fundamental civil and political rights, are viewed as being not absolute, but critical to the functioning of a democracy. And so the idea that governments can override them should be very concerning, and it should be exceedingly rare. Unfortunately, that's not. We're seeing an increased willingness and comfort with using it, and especially using it to target misunderstood minority populations, and that should be scary to all of us. There's a reason that constitutions protect minorities, because we recognize that they may not, the majority may not understand all of their needs and interests, and we could find ourselves in a minority at any moment. The Charter also protects the rights to be free from unreasonable search and seizure, a number of kind of police powers, freedom of expression, freedom of religion. And if governments are willing to override those rights at an increasing frequency, we should all be very concerned.
Bennett Jensen, thank you so much for your time and for your insight this morning. Director of Egale Canada, joining us this morning from Ottawa.